Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 2021 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On November 3rd, the court heard argument in New York State Rifle and Pistol Association v. Bruen, a case which concerned whether New York's law requiring that applicants for unrestricted concealed carry licenses demonstrate a special need for self-defense violates the Second Amendment. Examining oral argument today, we have Professor Adam Winkler of the UCLA School of Law leading off, followed by Professor Robert Leiter of George Mason's Antonin Scalia Law School.
Let me start with what I think would be a point of agreement between Robert and myself, which is that the New York law at issue in NYSERPA versus Bruen will be invalidated by the Supreme Court. Based on the oral argument, there appeared to be 6 solid votes to say that the Second Amendment guarantees a right to carry guns on the street for self-protection. For years, the court has refused to rule on concealed carry, as Nelson mentions. And this despite the fact that several justices have been complaining in dissents from the denial of cert and elsewhere that the Second Amendment is being treated like a second-class right. Simply the idea is that the lower courts have been upholding too many gun control laws. And we've seen that point of view articulated by Justice Thomas, Justice Alito, Justice Gorsuch. But even after Justice Gorsuch's appointment, there didn't seem to be enough votes on the Supreme Court to go beyond Heller. Well, what has changed? One thing that's changed is there is a circuit split, but that can't be the reason why the courts jumped into this. There was a circuit split even when Gorsuch was appointed, and that didn't lead to the court taking this case, the case on concealed carry. What's changed is the personnel on the court. That there have been 3 new appointees to the court, all chosen in part because of their anticipated rulings on issues like guns and abortion. And so while Justices Breyer and Barrett are out doing public events trying to convince us that law is not just politics, we all know that politics is leading quite directly to a constitutional revolution across a host of domains, from gun rights to abortion, from union rights to religious freedom. Now, the court in the NYSERPA versus Bruen oral argument seemed to be leaning towards reliance on what it terms text, history, and tradition to decide this case. The text provides arguably the best basis for saying there is a right to carry firearms, right? The Second Amendment refers to a right to keep and bear arms, which seems like 2 different rights, a right to keep arms, to have them, and a right to bear them, that is, to carry them. And the Heller case, Justice Scalia's opinion, said that bear arms means the right to carry in case of confrontation, unrelated to any malicious service. And while I personally think Heller reached the right result, we do know that since Heller was decided, there's a lot more historical evidence about the meaning of bear arms in the founding era. And frankly, it just doesn't support Justice Scalia's argument. We have, for instance, corpus linguistics databases of early English language texts from the founding era. BYU, for instance, has a corpus of founding-era American English that includes over 130 million words from a range of sources dating from 1760 to 1799. Well, what these corpus linguistics, these databases show, is that bear arms is used almost exclusively in a military context in the founding era. According to one study, 93% of all references to bear arms in the founding era was in a military context. Only 4% we're in a non-military context. You couple that with one, the text of the Second Amendment that clearly refers to militia service, and two, the fact that in none of the ratification debates, there is not a single statement in any of the ratification debates about a person bearing arms for personal protection against a criminal. Not one. The debate in the ratification debates was all about the militias. Occasionally, there was references to, as in Pennsylvania, defense of the state and themselves, but the people themselves. But the people themselves was always referred to in a communal purpose, a communal way, not an individual carrying a firearm in case of confrontation by a criminal. In fact, it's quite amazing. If we were to have a constitutional ratification today about the Second Amendment, there would be extensive discussion about personal protection, protecting your liberty against criminals. That's not how people understood firearms primarily in the founding era. Firearms were primarily offensive weapons because the nature of the technology was that it was a bad idea to store a loaded firearm in your home. In fact, some places like Boston prohibited you from doing so because gunpowder was highly explosive. And even if you had a firearm for your home for personal protection, if someone's coming in the window, it would take you over a minute to load that firearm, and you'd only get one shot through a firearm that was not rifled and thus probably was inaccurate. You just didn't use firearms for self-defense the way we would use them today. And indeed, if we look beyond text and to history and tradition, we find at best weak and ambiguous support for a right to carry outside of militia service. Tennessee in 1821 passed a law saying you can't carry concealed firearms at all. Texas in 1871 said you have to show a need to be able to carry a firearm. West Virginia and Alabama had need-based laws too. And by the way, those laws were only defenses. They weren't permitting systems. You'd have to go to trial if you were carrying a firearm and rely on a jury to determine that you had an immediate need to be armed. The challengers in this case cite a couple of cases that invalidated bans on concealed carry, including Bliss versus Commonwealth in Kentucky of 1822, Nunn versus State in Georgia in 1846. But there are at least 26 cases over the past 150 years that go the other way and that uphold bans or extensive restrictions on concealed carry. Moreover, there's a long tradition of restrictions on concealed carry, including nearly 100 years of concealed carry permitting on the basis of a showing of special need. Now, in fairness, today such laws are pretty rare. At least 40 states have revised their concealed carry laws to eliminate the need requirement since the 1980s. In my opinion, despite the justices' professed commitment to text, history, and tradition, the ruling that comes in NYSERPA versus Bruen will instead reflect a living constitution, the evolving understanding of the Second Amendment and the right to carry concealed that has shaped American law over the last 40 years and is about to find its final crowning achievement in the Supreme Court. So what is next? Well, some people think that this case is the end of the battle over concealed carry in the United States. But I would suggest that we're likely to see states fight vigorously to prevent concealed carry, much of they have done in the abortion space, and try to fight against the Supreme Court's rulings. And the oral argument, I think, made clear where those battles will take place, over what counts as a sensitive place. Heller said that the Second Amendment does not prohibit government from adopting laws that restrict guns or prohibit them from sensitive places, such as schools and government buildings. And in the oral argument, several justices asked about whether a right to carry would extend to potential sensitive places, like the New York City subway system, to Times Square on New Year's Eve, to college campuses, and even Yankee Stadium got a shout out in the oral argument. My prediction is that places like New York and places like California are likely to very broadly define sensitive places to make it extremely hard or unattractive to carry a firearm, even if you have a permit. You might be able to get a concealed carry permit, but it's going to be very burdensome to actually carry the firearm. due to restrictions on sensitive places. This is going to lead to a lot of litigation. And it's very hard to imagine how the court will be able to define what counts as a sensitive place with any kind of clarity. Is it a place where people crowd together? Well, I'm not sure that all government buildings meet that standard. And don't we need to defend ourselves where the other people are? Is it a place that has its own security? Well, but that means that schools and government buildings are not all covered. I'm Zooming to you from UCLA Law School, both a school and a government building. And we have no security here on campus. There's nothing that stops anyone from walking onto campus with a firearm. Justice Kagan asked Paul Clement, who was representing the challengers, if he had answers to these questions and gave him a laundry list of potential sensitive places. What was so remarkable about the oral argument is that Clement had no answer. And he said, I just don't know how those questions are going to cash out. So we had an advocate telling the court, allow guns everywhere, but I'm not going to provide any clear answers on what remaining limits or boundaries to that right. In any ordinary circumstance, we'd say, what is the limiting principle? And Clement would have had to say, I don't have one. And presumably the court would be hostile to that argument because of it. But if the court thought that viability in the context of abortion was an unmanageable standard, just wait until the wave of cases over sensitive places. Just one final note in closing, let me say, let's all hope the court firmly rejects another argument that Paul Clement made in the oral argument about the historical pedigree of gun laws. When applying history and tradition, Paul Clement said, we should only look to gun laws on the books in 1871 or before, when the 14th Amendment was finally ratified. Well, is that really the case? Back then, no state barred felons from possessing firearms. No state barred the mentally ill from possessing firearms. No state barred domestic abusers from possessing firearms. And no state barred guns from sensitive places. Ironically, among the few gun laws on the books before 1871 were bans on concealed carry. And the Supreme Court, in the name of history and tradition, is about to strike those down.
Thank you, Adam. And there are parts where I'm going to vigorously disagree with Adam, but there are parts where I wholeheartedly agree with him as well. So I want to start off by talking a bit about the New York Sullivan Law and how extreme the law actually is. So New York generally prohibits individuals from possessing firearms except pursuant to a license. And then it issues civilians one of two kinds of license, either a premises license, which is valid for a home or place of business, or a carry license, which is without regard to employment or place of possession. Now, both licenses require good moral character, but a carry license additionally requires proper cause. Now, contrary to popular belief, New York does not ban individuals from carrying handguns openly. Any method of carry, either openly or concealed, requires a license. Now, what is proper cause? Proper cause is left to the near complete discretion of the licensing official. And I hate to be a legal realist about it, but proper cause is whatever the licensing official says it is. So in most New York jurisdictions, sporting uses such as target shooting and hunting definitely qualify as proper cause. But New York courts have also held that when licenses are issued for sporting reasons, the licensing authorities may restrict the license to that purpose. And strangely, these administrative regulations have no legal effect. They're basically a conditional threat. If you carry a gun outside the reason for which I've given you this license, then I'm going to revoke it. Now, what about self-defense? In most of the rural counties, these licenses are available to anyone who's of good moral character. Most will issue them on what's often called a shall issue basis without any special need requirement. But most of the urban jurisdictions do. In these jurisdictions, a person must demonstrate a special need for self-protection distinguishable from that of the general community or of persons who are engaged in the same profession. So it's not enough to be in a high-risk profession like a taxi driver who has among the most dangerous jobs when you measure it by risk of work-related homicide and assault. You have to be a taxi driver who has a higher risk than other taxi drivers. And in practice, the proper cause standard for self-defense varies very widely. Some jurisdictions may issue it to business owners who deal in cash. Others effectively restrict licenses only to very high cash businesses or to people with documented death threats. And there are three things that make New York's law particularly extreme. First, getting a license for a non-business reason is tricky. You have to have a serious enough threat to your life that you can convince the licensing official to issue the license, but the threat can't be so imminent and so acute that you can't wait the over 6 months that it takes a licensing official in New York to process the license. So you're sort of stuck in a catch-22. Second, judicial review in New York is practically non-existent. New York courts have all but ignored Heller. Licensing officials have broad discretion to issue a license, and they can deny it for any good cause. And even after Heller, a court will review whether the licensing official has a rational basis to deny a license. So licensing officials can basically do what they want subject to the most minimal judicial review. And this has been an issue that did come up during oral argument. Third is that New York almost completely bans non-residents from possessing handguns. If you don't live or work in New York, you can't get a license. And if you can't get a license, you can't carry a handgun in New York in any location, rural or urban, for any reason except for some limited organized competitions. And so with this background in mind, let me talk about what this case is really about. The question in this case is whether a state can generally ban most of its citizens from carrying firearms in public for self-defense by restricting self-defense licenses only to those who have demonstrated an individual particularized need to carry a firearm. And despite some attempts at obfuscation, this case is not about any of the following. It's not about whether law enforcement officers can exercise some discretion about an individual's suitability before licensing a person to carry a gun in public. It's not about whether the state can prohibit firearms in sensitive areas or any other narrowly defined public place. It's not about whether the state may more rigorously regulate public carry in urban versus rural areas. And it's not about whether a state may prohibit the carrying of concealed weapons when it leaves individuals free to bear arms openly. And it's not necessarily about the precise standard of review for Second Amendment claims, although the court might shed some light on that question when it decides this case. All right, so from that background, let me talk a little bit about oral argument in the case. So much of the oral argument focused on how the court should review Second Amendment claims, particularly how a text history and tradition test would apply. Now, I do agree with Adam that when it comes to the right to carry arms in public, the text, history, and tradition test is more complicated than it was in Heller. When we look at the issue in Heller, which is whether an individual had any right at all to keep arms in the home if he was not enrolled in an organized militia, I think there's virtually no evidence that the framers conditioned the Second Amendment right on that. And if you look at Justice Stevens' dissent in Heller, for example, it results from confusion and equivocation about the militia, which he treats as a state army rather than as a civilian or citizens army. But the history of public carry is more mixed, and there are some historical facts that provide superficial support for New York's view. You have the Statute of Northampton, which was passed in 1328, which restricted going armed in fairs, marketplaces, before the justices and elsewhere. There was some common law power of justices of the peace to require those going armed to post sureties to keep the peace. And after the Civil War, many states embarked on an effort to restrict the carrying of handguns, whether openly or concealed. Now, most of the total bans on carry were struck down in part, but a few survived, with Texas having probably the most extreme regulation of any jurisdiction that was upheld by a court. But with that said, there are a lot of facts that once you get past the superficial level do support the petitioners quite heavily. So first of all, at the time of the framing, there was virtually no regulation of public carry as such. So whatever the Statute of Northampton might have meant in England in 1328, by the 1700s, the offense was largely in desuetude, and it was at most, when it was rarely applied, it was only applied to those who carried arms in a manner that would naturally lead to a breach of the peace. But the offense itself was almost completely unenforced throughout most of American history. In America, as Adam alluded to, the major efforts to restrict public carry begin in the South, and they begin in the early 19th century with laws that are designed to restrict the carrying of concealed weapons. And from here, what we see is a liquidation of the constitutional right. So I agree with Adam that if you look just at what the framers said in 1791, they say very little about they say nothing about individual self-defense against crime. Virtually all the discussion took place around the organization of military power and dividing it among the federal government, the state government, and the people as a whole. But if you look at what the First Amendment meant in 1791, no one talked about sports pages and whether sports reporters would be, whether that kind of reporting would be covered. They were obviously focused on political discourse. So I don't think you can infer from exactly what the debates were all of the limits of the substantive rights. I think the framers expected, as with other constitutional provisions, that their meaning would be liquidated as time went on. And when you look at how it liquidated in America during the 19th century, most of the laws against carrying concealed weapons were upheld because they were considered regulations, not prohibitions of the right to bear arms. And Adam's scholarship notes this with some detail. But this is important because most state Supreme Courts recognize a general common law right, which was codified in the Second Amendment and state constitutions to carry arms in public. So I will close by saying that in the argument itself, three things stood out to me. First, there was very little discussion at oral argument about the statute in Northampton or about the surety laws that about 10 jurisdictions adopted, which required those who carried guns to post sureties except when the guns were needed for self-defense. Debates about these laws were featured prominently in the briefs, but the oral argument barely scratched the surface. Second, there was a lot of debate about how you implement a text, history, and tradition test. If the petitioners prevail, there's a whole bunch of questions that are going to be raised. Does it mean, for example, that individuals only have a right to bear arms openly, or can the legislature choose among open or concealed carry? And how do courts determine what locations the legislature may ban from public carry entirely? And here I do agree with Adam that I thought Paul Clement's answers were at his weakest. When he ducked some of the questions regarding bars and universities. And the history here is probably less favorable than gun owners want. As Adam's research has shown, most state courts have upheld extensive regulation on public carry, but the key is as long as they're not a general ban. And that's what separates those cases from the New York case here. The New York case is much more extreme. And finally, there's the question of the level of specificity or generality with which the court examines historical precedents. And you could hear, for example, the liberal justices on the court examine the precedents at a high level of generality and say, well, the history's mixed and they're just going to defer to the legislature. The conservatives started with the idea that the text of the amendment enshrines a right to bear arms, and they wanted to understand how the precedents would explain the limits and exceptions of that. And I think here a lot of the 19th century cases will be helpful. The right to carry arms is unlike some of the other gun control questions we have today about machine guns or felons, which have no historical analog. Here we do have a robust American law on the right to carry arms. So in conclusion, I guess my predictions for the case, always dangerous. One, I agree with Adam, the petitioners are going to win in some form. I think the decision will be more originalist than the dissent, but it'll be less originalist than a purist would want. Second, there are several ways I think this case could go sideways, including a consensus remand for more fact-finding or an effort to narrow the extreme discretion in New York's law. And some of these could be a very Pyrrhic victory for gun owners. And finally, I totally agree with Adam that any decision in this case is not going to radically change the right to bear arms in public. States that do not want to allow public carry have many ways to take countermeasures against the court's decision, and they will effectively narrow the right to something that is unusable or will basically be restricted maybe at most to somebody's vehicle.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.